you in accordance with your statutory obligation to support that.
Good morning.
Good morning, Your Honor.
All right. Got everybody?
Your Honor, just as an administrative note, I do have a jacket available if the court would prefer.
No, you are fine. I did a trial last week with somebody at the airport wearing a t-shirt that said "Smoke Trees," so I think we're okay.
Well, I just wanted to be respectful to the court, Your Honor.
That's fine. I think it may be our last couple months of Zoom, so we'll have dressed down until then.
Thank you, sir.
All right. We're here on the case of Barbara versus McMahon, 09 DR 897. Please enter your appearances.
It's Michael Chinopoulos, appearing for the mother and petitioner, Your Honor, of absolute law.
Okay.
Karen Bevan on behalf of Vince Barbera, who is sitting here to my right.
Okay.
And Miss Monica McMahon is here also, Judge. She's not in view of the camera. Go ahead and come around so the judge can see you. Bring your chair, Miss McMahon. You were just out of view of the camera, so that when you swear the witnesses, Judge, she'll be visible.
Okay. All right. Okay, so we're here on mother's motion to suspend time sharing, which was filed on April 15th. I've already have some familiarity with the matter, so Mr. Chinopoulos, it's your motion. Would you like to proceed directly to evidence?
Yes, sir. If you would swear my client.
Absolutely. Madam Clerk, can you please swear in Ms. McMahon?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Can you please state your name and date of birth for the record?
My name is Monica McMahon, born July 4th, 1982.
Okay. Please proceed, Mr. Chinopoulos.
Madam Clerk, can you hear my client sufficiently? Yes. All right. Ma'am, we're here today because you filed an emergency motion seeking to stop Dad from seeing his daughter, at least temporarily. So I want you to tell the court the reason that you're asking for this remedy.
For the safety of my child.
Why is she unsafe?
She is unsafe because sorry.
Go ahead.
I feel that she is unsafe because of messages I have received from her and bruising that I saw on her from an incident with him.
Tell the judge what date that was.
That was April 11th. For the bruising, there's a text message that I have from her on March 13th, where he also pushed her in the face real hard and said, F you, F you.
I'm sorry, Miss Bevan, you do need to speak up a little bit.
Hearsay, Your Honor, and we've already been through this at the injunction hearing.
Mr. Chinopoulos, would you like to respond to the hearsay objection?
I would, Your Honor. As the exception to child hearsay, we're talking about the abuse of a child here. Moreover, there's proper predicate laid, although I can go back over that, to show the court that this was a conversation in which the plaintiff was participating. And so I don't believe under 90.801B, it's actually hearsay.
It's the conversation between Miss McMahon and the child?
Correct, Your Honor.
And so you're reporting she's reporting what the child told to her?
It is, in fact, offered for the truth of the matter asserted therein, Your Honor.
Okay. In that case, I do need to sustain the objection for hearsay.
Understood, Your Honor. So, ma'am, would you please tell the court what you observed, not what your child said? The court's ruled that you cannot say what Tristine has said, but go ahead and please tell the court what you observed.
Your Honor, I'm going to object if we're going to rehash the injunction hearing where you made your ruling quite clear after hearing all of this.
Ms. Bevan, I'm going to overrule the objection. This is a separate hearing with a separate burden of proof and, quite frankly, separate remedies. So I do recall what happened in the DV hearing, but this is completely separate.
Okay.
All right, Your Honor, since you have an independent recollection of this case, which, by the way, impresses me because I'm sure you have many, We'll just shorten this up, Your Honor, and tell you that we are in fact standing on the same evidence. The burden is in fact different. It's preponderance of the evidence here, obviously with the best interest of the child under 6113. And since you know all the facts, Judge, we're moving for the remedy that father be time sharing be temporarily suspended until he gets some anger management and does some other things. I would also proffer, Ms. Bevan, would you object to my proffer about what the child's preference is?
Yes, I would object to that.
Okay, then I won't make that proffer, Judge, because I believe it's improper without opposing counsel's permission or consent. So we would stand on that evidence, Judge, and ask for the relief that the father get some treatment and assessment and treatment before he allowed to be around the child, and potentially take some anger management classes as well as parenting classes regarding how he handles the child with respect to corporal punishment.
So what you're seeking is anger management and parenting classes.
Well, I don't
And
think
that his time sharing be temporarily suspended until those are complete.
yes, sir, but I don't think both are necessary. I think one or the other is appropriate.
And for the record, you're relying on my recollection of the DV injunction hearing?
Yes,
That took
sir,
place?
and the small bit of evidence that Ms. McMahon did testify to today in the court's recollection of the facts, yes.
Okay. Well, Ms. Bevan, just as it relates to the evidence from the DV injunction hearing, do you have any objection with the court taking into account what the court heard and the evidence the court saw during that DV injunction hearing? And I just want to check the date because I believe that was May 7th.
I don't have any
Wait.
objection to that,
Yeah.
Your Honor. Mr. Barbera spoke his piece, and I'm sure you remember what he said also, so I have no objection.
Okay. Now,
Your
there was
Honor,
a little bit of direct examination today. Ms. Bevan, do you have any questions for Ms. McMahon based on just her bit of examination today?
I don't know if it's outside the scope, but if I could ask a couple questions regarding, I guess I'll ask a question. If there's an objection, we'll deal with it, if that's okay.
Okay. I want to make sure that to the extent she testified today, and she
Today,
has, that you have your opportunity for cross-examination.
Okay. Ma'am, has Tristine seen Mr. Barbera since the last hearing?
She has seen him once.
And he took her to counseling, did he not?
Yes, ma'am.
And then she wasn't allowed to go with him to counseling after that date, correct?
now, Judge, I'm going to object to the outside the scope there.
It is outside the scope, but I'm not going to be preventing, it is outside the scope of your examination, but I'm not going to prevent Ms. Bevan from getting into stuff that's occurred subsequent to the hearing if she wants to during her case.
Understood.
Okay. So I'm sustaining the objection for outside the scope as of right now, Ms. Bevan.
Okay.
Doesn't stop for you from calling her and asking those types of questions in
Okay.
your case.
I don't think I have any questions on that then.
And
Okay.
to make this run more efficiently, Ms. Bevan, I wouldn't object to, she's under oath, just do your direct, your cross all at once so we don't have to go through the formality of recalling her. If you want to call her direct, please do.
Okay.
Yeah.
Then-
All right, then we'll just continue her examination right now, and Ms. Bevan will be able to ask her questions that are outside the scope of your direct.
Okay. Thank you. So, ma'am, you didn't allow Tristine to go to counseling with Mr. Barbera after the first time. Is that correct?
I have not stopped her from seeing her father at all.
Was law enforcement at the house last Friday?
They were at my father's house last Friday that I know of, but I was not there.
And was Tristine there to your knowledge?
She was not. She was with me.
Okay. Why was Tristine texting her father that why are you outside with the cops?
Objection assumes fact. Objection assumes facts not in evidence, Judge.
Overruled to the extent she knows.
If you know.
May you repeat the question? I'm sorry.
Why was Tristine texting her father asking why he was out front with law enforcement?
No.
because she wanted to know why he was at my grandfather's house with police. She did not want to go with him. I don't think to them.
You have allowed.
I'm sorry, I didn't hear that last bit, Miss.
I said she did not want to go with him.
Okay. And has anyone told Christine that she has got to see her father?
Christine has been told she needs to see her father. I talk to her about it every single day.
Have you encouraged her to see her father?
I have. She does not feel safe. I tell her every day she needs to text him and call him and still communicate with him.
But you have not physically helped in getting her to see her father. Is that correct?
I'm sorry, what does that mean?
Have you taken Christine to see her father?
He has not asked me.
That wasn't the question. Have you taken Christine to see her father on his days?
If he asked, I would have.
You would have
I
done
would
that.
have met them somewhere, absolutely.
Okay. Have you told your father not to let Christine leave with her father?
Absolutely not.
Okay. Are you familiar with Christine's grades?
Yes, ma'am.
Okay. Are you aware that she's getting Fs in almost all of her classes since the last hearing?
I am aware. They have also been in testing. The grades have not changed. Nothing new has been put through. I know that on virtual learn day, which was Friday, she did very good on the assignments.
Okay, but she's got an F average in all of her classes, and that's okay
She
with
has
you?
3 Fs, a D, and an A.
Okay, what is the A in?
I'm sure it's PE.
Okay.
I'm sorry, I couldn't hear the witness.
Yeah, you're the witness. Go ahead and speak up. I've moved this as closely as I can. So if you need to get closer to it, move your chair. Okay.
Physical education.
Okay.
Is that better? Can you hear her?
Yeah. I just couldn't hear that part. It would. Go ahead. I'll let you know.
Thank you.
Do you help? I'm sorry. Do you help Christine with her homework?
I do.
Okay. Do you make sure she gets her homework turned in?
To the best of my ability, but I am not at school with her to have her physically turn it in.
Okay. Have you told her she needs to go to counseling with her father?
I have told her she needs to go to counseling.
But you have not made her do that?
I have not physically forced her to do that, no.
Okay. What is the normal schedule, the parenting time schedule?
The normal parenting time schedule would be Christine with me Monday through Wednesday. I drop her off at school Thursday morning, and then she's with her father until he drops her off at school Monday morning.
Okay. And that schedule has been working, is that correct?
It had been, yes, ma'am.
Okay. I don't think I have anything further, Your Honor.
Mr. Chinopoulos, do you have any cross as a result of that examination? I guess we call it cross because it was Ms. Bevan's direct.
Yes, sir, I do. And I'm going to urge the court to, on my cross-examine, reconsider the court's ruling on my child hearsay response to objection, in that I believe Ms. Bevans has now opened the door, and under 90.803, paragraph 23, and under 807, Judge, I believe that it's now proper for her to testify as to what the child said about the abuse.
Can I respond?
I'm going to overrule the objection for now. She asked questions that didn't necessarily require testimony about the child hearsay, but it was offered by the mother.
Understood, Judge. Then I have no cross-examination for Ms. Bevans, Your Honor. I mean, I'm sorry, following Ms. Bevans, not for Ms. Bevans. Although I would cross-examine you, Ms. Bevans, is what that means.
Got it. Okay. Mr. Chinopoulos, do you have any other witnesses or evidence you want to present?
I do not, Your Honor, with the one exception that I'm not going to call Mr. Barbara so long as the court tells me that you remember Mr. Barbara's previous examination and cross in the domestic violence hearing, then I need not repeat that here.
Okay. I mean, I remember it generally. So.
All right. Well, I will go ahead and briefly cross Mr. Barbera, Your Honor.
Okay.
He is not sworn yet, Your Honor.
Madam Clerk, can you please swear in Mr. Barbera?
Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Sir, some time ago during this incident, your daughter had bad grades. Is that correct?
Yes, sir. She's continued to have the bad grades. I have report cards.
Sir, my question was, did she have bad grades at the time? She did,
Yes,
right?
she did.
Okay. And as a result of that, you chose to punish your daughter, correct?
Yes, sir.
And as part of that punishment, you took away her electronics. Is that right, sir?
Roger that.
And unfortunately, sometime after you as her father told her she was not permitted to use those electronic devices as punishment for her grades, she chose to disregard that and do so. Is that correct?
Roger that, sir.
And then you took some parenting steps to address that. One of those parenting steps was you took and smashed the electronic device that she had, correct?
Roger that, sir.
And one of those parenting steps that you took was to spank your 14-year-old daughter, correct?
Roger that, sir.
And you hit her with a belt, right, sir?
Roger, sir.
And you told her F you, right?
Negative.
And you told her, if you use those things, I'm going to break every effing one of them, right?
I told her mom that. I did not tell that to the daughter. I told her
Okay.
mom that through a text message.
And when she resisted your spanking, you grabbed her by the hair and got more aggressive and hit her with a belt, right, sir?
No, sir. No, not at all. The
And you
only
left
time
the
that I
marks.
spanked, the only
Sir,
time
you
that I
left the marks.
Sir,
You
you're asking
said
me-
no.
Hold on. Mr.
Thank you.
Chinopoulos, let him finish.
There's a lag here, Judge. I'm sorry, sir. Go ahead, Mr. Barbara.
Okay, the only time that I spanked her, there was no grab her by the hair. There was none of that stuff. Okay, when I caught her in her room with that laptop, okay, I had her come out to the living room. I sat down on the couch and put her across my knee. Yes, I did spank her with a belt. Okay, as she could say, I was pulling her hair as she was on my lap, and she, of course, a kid's not going to sit still whenever you're giving them a spanking. You know, she could say, yes, oh, I was pulling her hair. I wasn't intentionally pulling her hair. You know, I was trying to hold her and give her spanking for disobeying me. That was it. There was no intentional. I grabbed her by the hair and was, dragging her around or anything like that. No, I put her across my knee. I gave her a spanking while she was struggling. She has if you've ever seen my daughter before, she has a full head of hair, a huge head of hair. Okay. During that time, of course, maybe I pulled her hair, but I wasn't grabbing her hair to intentionally yank it and pull on her hair. That's not what happened.
I understand. And the last time when we talked at domestic violence hearing, you admitted to hitting your daughter with a belt and leaving the bruises that were shown at that hearing and entered into evidence, right, sir?
Yes, sir. I hit her with the belt. I don't know if the bruises was not. You could see the two belt marks that was from the belt. What the other bruises were from, I do not know.
Understood, sir. And you believe it's appropriate to use a belt to discipline your child, correct?
At the time, sir, I have been going through this with Mrs. McMahon for a long time now, where you can see in the.
Your Honor, I object and ask the answer be stricken if the witness be instructed to answer the question.
Yes, Mr. Barbera, please just answer the questions that Mr. Chinopoulos asks. I know you want to be able to say more. You'll have your opportunity when Ms. Bevan asks you questions. So please, for now, just answer Mr. Chinopoulos' questions.
Roger that, sir.
It's appropriate to discipline your child with a belt, right, sir? That's your opinion?
At the time, I guess it was because I was upset.
Okay, so you were upset. So the spanking was for you, to get rid of your stress, to get rid of your anger, not to discipline the child, right, sir?
Absolutely not. I would not.
And you'd do it again, wouldn't you, sir? If she disobeyed you, she right in your face looked at you and did something you told her not to do, you'd hit her with a belt again, wouldn't you, sir?
No.
Oh, okay. All right, I have no further questions, Judge.
Ms. Bevan?
May I just start my direct?
What?
May I just start my direct to save time?
I think probably for the sake of time, we do need to do that because I think this was only scheduled for 30.
I have no objection, Judge.
Okay. All right.
Mr. Mr. Barbera, when is the last time you saw your daughter?
Can you speak up, Ms. Bevins?
Mr. Barbera, when's the last time you saw your daughter?
It would be the April 12th, whenever I dropped her off at school that morning.
Okay. And since the hearing, have you seen your daughter?
No, ma'am.
Did you take her lunch at school?
Yes, I did.
Okay. When did you take her lunch?
An exact date, I'm not gonna know the exact date. It was 3 weeks ago, Thursday.
But it was after our hearing.
Yes, ma'am.
Okay. And did you go to counseling with your daughter?
Yes, ma'am.
How did that come about?
I went to counseling on my own to help myself understand a better way to take care of her and discipline her at the same time without causing harm.
Okay.
I wanted my daughter to go there so that I could better understand, what she was thinking and how she was feeling, and a better way for me to try to help her right now because of all the things that I'm seeing. I'm very scared about my daughter's future.
How did you get your daughter to go to counseling with you?
I asked her to go, and I went and picked her up. I made an appointment a week before that. I decided not to go, and then I talked to her again, and she said yes, she would go with me the second time. And I went to the school and I picked her up and I took her to counseling. But I told her, that I would take her back to her after counseling and drop her off.
I'm sorry.
Yeah.
That I would take her back.
Could I ask Mr. Chinopoulos to put his mute on when he's not talking?
Yeah.
I'm sorry, I was asking her to get some doc.
Thank you.
Thank you.
Madam Court Reporter, what was your question?
Well, he started answering. Okay, I have a question. How did you get your daughter to go to counseling? Answer, I asked her to go. I went and picked her up. I made an appointment a week before that. I decided not to go. And then I talked to her again. And she said, yes, she would go with me the second time. And I went to school and I picked her up and I took her to counseling. But I told her, and then I told her, that I would take her, and then I couldn't hear because I had the two people talking at the same time.
Okay.
Do you mind if I inquire?
Sure.
You said you started counseling.
Yes, sir.
Who did you start counseling with?
I'm going to counseling in Southwest Florida.
When did you start counseling?
Sir, I'm not going to know the exact date. I went 2 weeks prior to taking my daughter. I would have to actually call them and find out the exact dates.
Was it before or after we had the DV hearing?
I want to say that the first time that I went was before the hearing, when I went by myself to a personal counselor. And then the second time I went with my daughter to family counseling was after we had the hearing.
Was it before or after the incident that is the subject of their motion?
It was after.
Why did you feel like you needed to go to counseling?
Because I need to figure out a better way to deal with my daughter to where I don't make her feel uncomfortable being, with me, or, I was raised, sir, in a very strict family to where my mom and my dad used to beat me, and I guess not beat me, but I would be whipped with a belt, held off the ground with one hand and beat with a belt by my dad. My mom always made me go out and get switches and beat me with switches. And so I grew up, that way. And I've never intentionally went out of my way to do anything to my daughter physically, because I never wanted her to feel that way about me, feel the way that I feel about my parents. But my daughter, she's been doing some really bad things. I have proof from people telling me that she's vaping. I think that her grades are really bad right now. I have all her report cards right here that are showing that since the 2 months that she's been out of my care, I had all of her grades up above F's. I had them A's, B's, C's, and D. She had one F. And now these report cards that I have here in front of me, she has all.
Let me stop you. What have you taken so far from counseling that you've done?
What have I taken so far?
What have you learned?
I guess the main thing that I learned is I need to be a lot more. I need to think a lot more about my actions and how it will affect my child, and rather than taking it out violently, I need to try to speak to her more and talk to her about how we fix the situations, because obviously and I don't believe that violence is a key, but I didn't know how to handle it at that time. I'm afraid, I've worked so hard for my daughter in the last 14 years to get her where she's at, that I don't want to watch what I've built, the chances that I've been giving her with her future, because she has potential that's out of this world, to fall, or her to lose, what we've been working on. So I just needed to learn a better way to communicate with her and make her understand that some of the things that she's not doing, that she is doing, is not the right way to go about them. Hiding things from me. There's no reason for her to hide anything from me. I've always been there. I've always supported her. She even comes to me and tells me things that I don't think that she would tell other people. Things that happened to her at school, things that happened to her friends at school. I have a very open door with my daughter. I do everything I can to listen to her first, but whenever I do catch her doing something that she doesn't have to do it behind my back. She didn't have to go and hide that tablet behind my back. When I restrict you from doing something, you don't have to go and hide it from me. There's no reason.
So if a situation occurred, again, like the situation that occurred that led us here today, and you found her basically doing something contrary to what you told her she could do, how would you handle it differently today than you did then?
Well, number one thing is I wouldn't spank her. I'm not going to let that happen again. I made a mistake. I know I did, but again, I was raised that way. I mean, of course, I'm going to enforce, that she's, restriction is restriction. If you're doing something bad, there has to be some sort of punishment. I can't just turn a blind eye to it. Her getting these bad grades in school, she's been with her mom and her grandfather for 2 months now, and her grades that were good.
I'm not interested in that. Tell me, how would you handle disciplining her?
Well, I mean, I think I would continue with, restriction to her room. I mean, tablets, electronic devices, she doesn't need those type of things. Those things are causing more damage than they are anything. She spends 9 hours a day. She's averaging on these devices, and she's getting bad grades in school. So I would restrict her from using any of those type of things. These are not things that a child. I grew up my whole life without a telephone. So why today should I believe that, that's something that a child has to have, especially a 14-year-old girl that can go online and look at all the bad things that are happening online? Because when you go online, I mean, what do you see? You see sex and drugs and partying, and like all this is just natural. And those are not things that I believe my 14-year-old daughter needs to be exposed to.
What's your schedule with regards to counseling?
Well, at this point, sir, to tell you the truth, I went the 2 times to counseling. I was supposed to go a 3rd time to counseling with my daughter. The counselor gave us a thing where we had to write a letter to each other. I wrote the letter. I was supposed to go last Thursday with her to counseling, and she won't go with me. She refuses to see me. So I haven't been back to counseling because I want to go through the counseling with my daughter, so I can figure out how to be a better parent, to help her as much as I possibly can, because that's what I've done for 14 years now, is do everything I can to support her. So I need to have as much input from her and her there with me for me to, I think, to make this better. you know.
All right, thank you.
Yes, sir.
I apologize for getting in the way of your examination, Ms. Bevan,
That's fine.
but those are questions that were most interesting to court.
Okay. What do you want to see going forward regarding the schedule, Mr. Barbera?
Well, I want to see my daughter.
Okay.
That's the number one thing. I need my daughter as part of my life. You know, she's been in my life for 14 years. I've given up everything for her. You know, so the number one thing is I have to see my daughter. I need to be part of her life, even if it is just, you know, I've got to protect her from the things that I think that I see going wrong in her life. So
Okay.
I need my time back.
Okay. So you want to go back?
I'm sorry, you cut out. Ms.
Hey, Rose.
Bevins. I couldn't hear you.
Oh, sorry. So you want to go back to the Thursday, Friday, Saturday, Sunday for you, and Monday, Tuesday, Wednesday with mom.
I want my 2 months of lost time back. I want my 2 months that I've been restricted from seeing my daughter back to me. You know, I don't think that this is fair what's been done to me. I've never done anything purposely to hurt her. Only thing I've ever done is try to help her. And I think that the mom is only doing this to hurt me. She's not doing this to help the child, or in the 2 months that she's been with the mom, the grades would not have went from A's and B's to F's.
Has Ms. McMahon been encouraging your daughter to spend time with you during this 2 months?
Absolutely not.
Objection, Judge. He has no way of knowing that. Lack of foundation.
I'm sorry, what was the question again?
I asked if Ms. McMahon has been helping him or encouraging the daughter to see him during this 2 months.
He has
And
no
your
way of
objection was
knowing.
what?
The objection was, Judge, that it calls for speculation. Mr. Barbera has no way of knowing what Ms. McMahon has or hasn't done outside of his presence.
How is it relevant, Ms. Bevan?
It's relevant that a 14-year-old doesn't really get a vote on who she sees or, you know, regarding her parents, and the parents are supposed to cooperate to facilitate.
How is it relevant to the motion to suspend time sharing?
Well, it's already been suspended unilaterally. Going forward.
Objection. Facts not in evidence,
Hold
Judge,
on,
and that's
hold on,
just
hold on.
badgering.
Hold on, Mr. Chinopoulos. She's not offering evidence. She's just, I'm asking for argument as to the relevance of this.
Well, his parenting time has been suspended unilaterally because he hasn't been able to see her. It seems that it is relevant going forward that if this child thinks that I don't have to do something because either mom says it or dad says it, we've got a 14-year-old calling the shots, and we should have parents encouraging a relationship with one another going forward. And the fact that the time has been suspended, I mean, this was originally set to be heard at the injunction hearing. We could have been less 2 months into him not seeing his daughter had this gone forward when the court originally said it.
Judge, I have to interpose an objection here. The question was, what has Miss McMahon supported you seeing your daughter? That's the question, Judge. We've gone way outside the reservation here.
I'm going to sustain the objection as it relates to relevance. That's how I'm reading your objection, because it's not relevant to what the current motion is before the court, which is your motion to suspend time sharing.
Okay, I'll move on.
Okay.
If time sharing is resumed, what do you think is in Tristine's best interest regarding counseling?
Well, I think it's very important for us to continue to go to counseling because we need to work through this, you know, together. You know, I mean, that's point blank and simple. It's important for us to continue with our counseling because how could I know what she's thinking or what's wrong if I don't get a chance to talk to her?
Okay.
You know, and it's in the counseling environment, she's going to feel safe because we're going to be there with somebody else that's an outside observer, and she's going to know that the only thing I do is love her, and the only reason that I do the things that I do is because I love her, and I want to see. All I want to see is good things happen for my daughter, and maybe by us going through the counseling, that she will come she will come to understand that, you know. But right now she's getting so many other outside influences that have her doing things that are totally unacceptable, you know. And I need her to realize the things that the things that she's doing is not what a real human, a way their life should be, you know, the way that they should be conducting themselves. She needs to understand that, you know, this is the right way to do things and this is the wrong way to do things. And I think as much influence that she gets from a counselor or any kind of other people that have a more positive outlook on life, that she's gonna benefit from that, you know.
Okay. All right. I have nothing further, Your Honor.
Okay. Mr. Chinopoulos?
Yes, sir. Sir, you just testified that you want your daughter to understand that you do the things that you do because you love her, right?
Yes, sir.
You want her to understand that you love her so much you beat her with a belt and leave bruises on her, sir?
Objection, Your Honor. Outside the scope and relevance.
Judge, it was his testimony. He opened the door.
I'm going to overrule the objections as it relates to outside the scope and relevance. Is there any other question, Ms. Bevan?
No, sir.
Okay. Then you may
Sir,
respond.
are you saying after one counseling session for you and one with your daughter that you've changed your mind? And I'm going to quote from your email on April 11th at 6:45 p.m. Let's see, when anything that the mother gives her comes into your house, okay, understand that anything that you give her when she comes into my house with it, I can do whatever the fuck I want to with it. Okay, understand, when she gets older, if you give her a fucking car and she does something fucking stupid, I'll burn that fucking car to the ground. She better understand some fucking respect. Are you telling me you've changed that attitude after one counseling session, sir?
What I'm telling you, sir, is I understand the mistakes that I've made. I understand that the things that I sent to the mother, okay, if you also read the rest of those text messages out to the judge, you'll explain to him how I've been begging.
Well, sir, Your Honor, I'm going to object as outside the scope of my question. His attorney can read whatever she wants to, Judge.
Just answer his question. Just answer the question,
Mr.
Just answer the question, Mr. Berman. Or Barrow, I'm sorry.
I know that I made a mistake, okay? And humans make mistakes all the time.
Judge, again, non-responsive, move to strike and ask the question and direct the witness to answer
Mr. Barbera,
the question.
please just answer the question.
I believe I have a lot of things to work on, sir. So, yeah, after the two counseling sessions that me, myself, and my daughter went to, I think it gave me a lot of perspective on what I have to do to help myself, and that's what I'm working on.
Well, let's be clear, sir. You went to one counseling session on your own and one with your daughter, right?
Roger that, sir.
And on, let's see, May 6th, you asked her to go to counseling, and she says, "Don't pick me up today because I still don't really feel safe going with you." Your daughter sent you that, didn't she, sir?
Objection, Your Honor. Hearsay.
I'm asking him what he knows, Judge.
Sustained.
All right. Sir, what would you propose that Miss McMahon do if Tristine doesn't want to go to counseling? Should she zip tie her and put her in the car and take her over to counseling anyway?
I didn't ask Miss McMahon to be involved at all. I believe.
Oh, okay. All right. Well, then I have no further questions.
Okay. All right. Ms. Bevan, any other testimony or evidence? We're pretty much out of time.
No, sir.
All
Brief
right.
closing, Judge.
No need because we're out of time.
Yes, sir.
Give me a moment. Okay. Let's first talk about what the ruling is going to be. As it relates to the motion to suspend time sharing, the court is going to deny that motion. The evidence from the DV hearing and what was admitted was that he spanked her with a belt. The pictures that were presented, which were basically two pictures, were all not that impressive as to any type of bruising that was done. And though he did admit to spanking her, there was no evidence of the more serious allegations that were made in the motion and the DV hearing, such as those included in paragraph F, that said he kicked her in the lower back and delivered a hard blow to the right side of her head. There was no evidence of support those allegations that were presented either in the DV hearing or here today. So just like in the DV case, there was not sufficient substantial or competent evidence for the injunction, and there was not sufficient or substantial evidence to support suspending time sharing. The evidence has shown that Mr. Barbera is a good parent, or at least is attempting to be, that he loves her, and that he wants to do right by her. The court was impressed by the fact that he went and started counseling before the DV hearing ever commenced, and he put himself into counseling before the court order. For all of those reasons, the court is going to deny the motion to suspend time sharing. However, what I do want to do is I want to talk about with the attorneys, while their clients are here, things that we can do to help and support Mr. Barbera in exercising his time sharing with his daughter. I think counseling is a great idea. There is no motion before me that would require the daughter to go for counseling. So I'm not going to do anything that is controversial between the two of you right now. But can there be an agreement right now for continued counseling that includes the daughter? First, I'll turn to you, Ms. Bevan.
Absolutely. He wants her to go to counseling with him.
And would he be willing to pay for that?
I believe he has,
Absolutely.
yes.
Okay. Mr. Chinopoulos, is there any reason why we can't agree to that as part of a court order?
Yeah. Do you understand what the judge is saying?
Mr.
Do you
Chinopoulos,
have
if
any
you want,
concern about that, man?
Mr. Chinopoulos, if you want
I'm
time,
happy to counseling.
I don't
sorry,
know if you
Your
want
Honor.
time to speak to your client on mute. You're welcome to if you want.
No, but thank you, Your Honor. Ms. McMahon is not opposed to that at all. She would like to take the daughter, even though she's not participating in the counseling, just to help keep her calm and go to the counseling.
Yeah, I think I have no issue with counseling that includes Ms. McMahon's involvement or doesn't include Ms. McMahon's involvement. I want to leave it to whatever counselor it is. Now, Mr. Barbera, what counselor are you going to, and is there any reason we can't continue with that counselor?
There's not at all, sir. I've been trying to go back to the counseling, but the grandparents, Miss McMahon keeps my daughter at her grandparents' house, and they refuse to release her to me. So I got to make sure that after today, that she understands that if she continues to keep my daughter from me, that she's going to be breaking the law.
Okay, we don't need to worry about that right now, because based on my ruling on the motion to suspend, there is no suspension of time sharing. It goes back to what's into the final judgment, and we all understand that. The question right now is, does your counselor do family sessions? Does it?
Yes, sir.
Okay, and is there any issue with the counselor that Mr. Barbera is going to now performing this counseling?
No,
You know who it is?
I don't know who it is.
It's Counseling of Southwest Florida. I don't have the lady's name. There was one lady for his personal counseling and another lady for the family counseling, but we can get that information. It is Counseling of Southwest Florida, though.
And I will offer to the court that I'm familiar with that treatment provider, and I would encourage you to accept that. They're well-qualified professionals.
Okay.
Okay. All right. So, Ms. Bevan, I'm going to have you prepare the order. Just a short order denying the motion, but also in the order ordering to counseling paid for by Mr. Barbera. I don't want to put in a number of sessions because I just don't know what the counselor is going to do, like what the counselor feels. The counselor can have sessions that include Ms. McMahon. The counselor can have sessions that just include the daughter. Whatever the counselor feels that they need to do. Obviously, Ms. McMahon, you're going to have to encourage the daughter to attend these sessions and bring her too, because whatever is going to happen going forward, at least for the next, she's 14 years old,
Yes.
4 years, you two are stuck and you're going to have to be co-parenting your daughter for 4 years. So we want to get it right. We want to do it so that it works the best for all of you all. And though I understand exactly where you're coming from, Ms. McMahon, about, I guess you would call it corporal punishment. It's not something that generally is encouraged, but it's not out of the ordinary. In fact, the case law that I've reviewed shows that the courts have recognized that sometimes it happens. Don't have to agree with it. Personally, I don't. And it sounds like, so far from what I heard from Mr. Barbera, he's seen the other corner and he's not going to be using it either going forward. So for all those reasons, I didn't think that there was any type of immediate danger or risk of harm to the child based on what I've heard as far as evidence. But I do completely agree that something needs to be done to be able to bring your daughter and her father back together again. And that's what we're trying to do here today. Ms. Bevan, do you have any questions as it relates to the court's order?
Just that since the motion is denied, we're going back to the regular schedule, and tomorrow is Thursday, so we anticipate Dad getting the daughter from school tomorrow.
Okay. Mr. Shinopoulos, do you have any questions related to the court's
Your
order?
Honor, no, sir, and I believe that is true, that he will get Tristine tomorrow at school. I would just ask the court, I mean, if Tristine chooses not to go, I'm not sure where we go from there. And perhaps that's something Ms. Bevan and I discuss outside the court's purview and maybe come up with a strategy to deal with that.
Well, the time where a 14-year-old is the one who gets to dictate is never.
Right.
But it's nothing that I'm going to be able to decide now because we don't know how it's going to be. That's something that I would definitely encourage you and Ms. Bevan to speak about and maybe preparing the daughter for, which is something I can't do.
And I would hope that we can work together to encourage her to not be making decisions.
And that's why I'm saying that is I think we'll confer outside the purview. If you'll keep your client there, I'll keep my client here, and perhaps we could brainstorm. So in the event that she chooses not to go or expresses that, we have a contingency plan and both parents are on the same page as to how to handle that issue.
That would be great. I really appreciate you all doing that.
Okay.
And I thank you because it's, like I said, you all are going to be co-parenting your daughter for another 4 years together. Long after these hearings and long after counseling. So this is going to be a great start that I hope to getting back on the right track towards that and to building the relationship that the daughter needs with her father.
Okay.
Understood, Your Honor.